Your Honor, I would like to reserve 5 minutes of rebuttal.
All right.
This case involves a dissolution of a 26-year-old marriage. It began in 1993 between these parties, and during the marriage, the husband was the primary breadwinner and the parties lived upon his earnings. What he made was deposited into joint accounts and shared jointly with the parties. In 2007, the parties opened an account at E-Trade. It was a joint account. It was opened by the husband. He was listed as the primary account owner, and the wife was also listed as an account owner as well. The wife in 2011 received as a gift from her grandfather 55,000 shares of stock in Bristol Myers Squibb, or BMY is the stock ticker that we may refer to. And with that 55,000 shares, both with the knowledge of her grandfather, the donor, and the grandfather's attorney, Mr. Snyder, she decided to deposit those shares into the joint brokerage account of the parties. This was approximately year 19 of this long-term marriage when this decision was made. Subsequently, the grandfather passed away and left through a trust of which the wife was the trustee, along with her uncle, additional shares to the wife. And in 4 separate occasions in 2012 and 2013, July of 12, December of 12, June of 13, and August of 13, again with the knowledge of the family attorney, who was a co-trustee of the trust, deposited those additional shares received through trust into the joint brokerage account. These shares kicked off considerable dividends during the marriage, and the parties lived an excellent lifestyle based upon that income, as well as income from other investments contained in the joint E-Trade account. Stocks that had been purchased during the marriage, stocks that the husband managed, he would purchase and sell, and he would control this account with unfettered access and control during the entirety of the time that it was in existence.
But there is no dispute that the stocks themselves remained untouched, correct?
Correct. So the BMY stocks that were deposited into the account were never sold or traded, and it is undisputed that those stocks stayed in the account in the form in which they were initially deposited. The dividends would be swept into a sweep account, and the parties would expend that cash on their marital lifestyle. They would expend it on cars, on their luxury expenses.
Your best argument on the Bristol Myers stock, as I read it, is probably that the wife placed the stock in the party's joint account when she could have maintained it separately. Have I got to the nut of that?
Correct. And so, you know, and this wasn't a mistake or some kind of trickery. She had legal counsel at the time advising her that placing it into the joint account, you know, could effectuate a gift. And the only way to avoid that is they offered oral testimony before this deposit was made, that was discussed at the meeting. And the wife is essentially the only witness who says, oh, well, Corey promised me he was never going to claim this stock. That's not how we believe you rebut the presumption of a gift when you title something jointly with the spouse. And in particular, it was all oral testimony from a 2011 meeting. That meeting says really nothing about the 4 additional deposits in 12 and 13, nor does it account for the fact that after the meeting, the wife decided to go forward and put it in a joint account. And so there are ways to acquire something separately, and that's what the statute speaks of.
Well, when we get to the part about rebutting the presumption, the trial court made pretty detailed findings and made sure that the way that they were presented established clear and convincing evidence sufficient to rebut the presumption. So a lot of what I feel like you're asking us to do is look at the trial court's factual determinations on whether this presumption was rebutted. Help me out with that.
Yes, Your Honor. So we've cited the Clawton case, and the issue is the sufficiency of that evidence that the trial court relied upon. And under the Clawton case, is it sufficient for a spouse to rebut the presumption solely with their testimony during a dissolution of marriage proceeding where they first claim that the no gift was made? And
well, it wasn't just her testimony, though. It wasn't just the wife's testimony. The trial court took into account Mr. Spam's testimony.
If you look at the testimony relied upon, each place where the court makes a finding, it starts with wife testified to this, wife testified to that. In fact, the definition of a non-marital asset says you have to have a valid written agreement between spouses in order to treat something as non-marital. And this is all loose oral testimony and raised for the first time during the dissolution of marriage. And in fact, the claim shifted during the dissolution case. It was initially the entire account was non-marital. And then when that position became untenable, the claim shifted to, well, just the BMY stock within the account was non-marital. So
well,
we're
but
not
that's
asking.
not an inconsistent position, though.
Well, it is an inconsistent position because there were considerable numbers of stocks that were purchased and acquired during the marriage. There were gifts that were made to both parties in cash that were deposited into the account and used to acquire other investments.
And at one point, everything else in the account but the BMY stock was liquidated, right? So the BMY stock was always treated differently.
Well, all it shows is that the BNY stock was not sold, and there were reasons for that. The 55,000 shares given by gift had a cost basis of approximately 13 cents. This stock was performing during the entirety of this marriage, both in dividends and appreciation, and there was a huge built-in gain, certainly on the first 55,000 shares, and the additional shares acquired in 12 and 13 received a stepped up basis as of the date of the grandfather's death of approximately $34 a share.
And that's the position that the former husband took in the trial court, right? And so the trial court had the opportunity to evaluate the truthfulness of that explanation?
Correct, but there's no evidence of any other explanation as to why the stock wasn't sold. I mean, the wife says, oh, well, you treated it differently because you didn't sell it. And then it was his burden at that point in time to come up with a reason for the trial court to say that. I mean, the fact of the matter is, when you boil it all down, it's solely the wife saying, I didn't have donative intent. And you know, the first time that claim is made is during the dissolution. And the court then shifts the burden to him. So why didn't you sell this stock? But when you really boil it down, they're trying to enforce an oral promise allegedly made in 2011 that he would always treat this stock as her stock, when in fact it was deposited in the joint account. They lived off the income derived from this stock continuously during the intact marriage. This is a long-term committed marriage at the time these deposits are made, and allowing this type of loose testimony to rebut the presumption really erases the presumption altogether. And it's precisely why, if you're going to make an agreement concerning an asset being treated as non-marital, the statute requires it be in a valid written agreement. And so there are really only two possible ways they could fit into the definition of a non-marital asset. One is that the property is acquired separately by gift, bequest, devise, or descent, which here, this property was put right into the joint account at time of acquisition, or secondly, they have a valid written agreement. And I would submit that the legislature places those requirements to establish a non-marital asset precisely so that courts are not placed in the position of dealing with loose testimony between spouses years after the fact. And what we have here in the way of objective evidence is the deposits, is the control of the account. There is no question but that complete control was relinquished. He had the right to trade these stocks in that account. He had a legal right to do that. The fact that he chose not to out of respect for his wife's wishes, she viewed this stock as a legacy
Mr.
for
Weber,
grandmother.
Mr. Weber, I just want to clarify something that you said about the trial court's findings on this. The trial court actually, she didn't just rely on the testimony of the wife. Her concluding paragraph, or at least close to the concluding on this, starting at the bottom of page 12 of the order, she finds that the husband's testimony was among the most compelling. And she treats his testimony for several paragraphs as part of her finding that the presumption had been rebutted by clear and convincing evidence. So to me, we're not talking about trying to enforce an oral promise. We're looking at whether the trial court's findings are supported by substantial competent evidence and whether that was clear and convincing.
So
and most of this has to do with resolution of conflicts among the evidence, the testimony of the wife, the testimony of the husband, the testimony of the lawyer Snyder, and even the son, as to how the parties treated this stock. And that's something that I'm sure you understand, we're not able to, meaning, that's not our job.
And I understand that, but what the treatment of the husband's testimony, starting there, is she finds him not credible because he doesn't remember this 2011 meeting and what was said. And so he didn't have the details of a 2011 meeting. So she says, well, I find he was incredible because he answered slowly when asked about what happened at that meeting or didn't remember any of the details.
No, I
And
think
so-
specifically what she found not credible was that he didn't believe the details concerning what was going to happen to this, what was it, $2 million worth of stock. So I think it was a little bit more narrowly drawn than that.
Well, he did know that it was being deposited into an account over which he had control. That was undisputed. And so the details referred to are this conversation at a meeting in April of 2011 is the detail she's faulting the husband for not remembering. And isn't this sort of precisely why this type of loose oral testimony about what we agreed to in the marriage on the front end is not what the court is supposed to be deciding the case on. And as it relates to the children, both of these children came in and gave diametrically opposed stories, and their understanding and knowledge of what these transactions were and the interactions of their parents, I would submit, cannot elevate this to clear and convincing evidence when the story is really predicated on what the parties discussed at a meeting in 2011 when these transactions are done. We have the objective acts. We have the fact that she had legal counsel and she had options and choices of what to do with it. And what she did do, that speaks for what she intended at the time. And here we are, we're faulting the husband saying, well, you didn't remember how the gift was done or the details of this meeting way back when. What he didn't remember was we put it into that account. And what did he, first thing he did after it was placed in the account, he followed up to make sure that the basis, and this is on the 4 distributions out of the trust, he spent considerable amount of time making sure that the basis was established correctly in the account. He voted these stocks. He voted the other stocks in the account. He monitored everything that was going on. He made, had discussions with his wife about the investment. I mean, he treated it as an owner the entirety of the time. And here we are, really essentially enforcing, well, this was what her intent was in 2011 when these deposits were made, when all of her acts were contrary. And again,
Mr. Weber, excuse me for interrupting, but you're into your rebuttal time. So use your time as you wish.
thank you. I would submit that this is not an issue about weighing testimony or asking you to reconsider the trial court's factual findings. It's about whether the evidence brought by the wife is legally sufficient to overcome this presumption. And the attorney didn't come in and testify to anything significant. He said the husband never evinced a statement that he had ownership of the 55,000 shares. Now, I don't know what that means, but I guess there was an expectation, the burden was placed on the husband to speak up at this meeting and say, I now have these shares. That's not what the law required him to do. And again, that doesn't say anything about the other 4 deposits that were made into the account. Which,
Mr. Weber, so you don't lose your opportunity to talk about the alimony. Let me ask you really quickly, what 2020 and 2021 business records were admitted at the trial? I know that there was testimony. I know there was the husband's financial affidavit, but what records of DM were actually admitted at the trial?
it was primarily the testimony of the forensic accountant that indicated that there really wasn't any business activity to speak of.
So does that mean that there were no documents from the business that were admitted? And you say primarily, I'm not sure what that means. Either documents were admitted from 2020 and 2021, or they weren't.
I believe there were returns, tax returns.
For the business.
I believe there were tax returns for the business. I think the business was a flow through to his personal.
Thank you.
Thank you.
Okay, Mr. Miros, Mr. Webb, we'll give you about 4 minutes on your rebuttal. And Mr. Miros, you are up.
Good morning, everyone. May it please the court, I'm Peter Miros and represented Mrs. Spann both in the lower court and today. And I'm going to try to make this very simple and brief because you all have done a great job in just getting down to the bottom line here. And the bottom line related to the issue concerning the Bristol-Myers stock is simple. There's no question whatsoever that it came from her grandfather. There's no question whatsoever it went into a joint account. There's no question whatsoever, but that we had the burden of proving by clear and convincing evidence that the presumption of a gift was rebutted. And we did that. And we did it in a number of different ways that I'm going to get right down to related to not only her testimony, but the corroboration. First of all, her testimony is certainly evidence that can and must be considered by the court in dealing with whether or not a gift was intended. Her testimony isn't simply, I didn't intend to give it to him. Her testimony goes into great detail with regard to the reasons that she did what she did, the reasons that she wouldn't allow him to control the Bristol-Myers stock, the reasons that this was never touched at all during the course of the marriage. So her testimony isn't a simple, which doesn't work, I didn't intend to give it to him. It's very, very detailed. In going further,
Mr. Miros?
Yes, ma'am.
What about Mr. Weber commented, and I do recall seeing it at one point, that the former husband had an ability to vote the stock?
Yes, that's a good question. I was going to get to that, and I'll deal with it right now. He had the ability to vote the stock, which was 100% totally meaningless in this case. This stock sat without any dealings whatsoever with nothing other than passive investments. a passive appreciation. There is no testimony that establishes in any way that voting the stock had anything to do with control of any nature. As you know, that they didn't offer any testimony on it, what voting meant. Voting, I think we all know, means that you get a notice of a meeting from the company and you vote yes or no on this, that, and the other. Nothing in the record to establish that voting the stock was in any way meaningful. I hope that answers the question. Getting on to rebuttal, in addition to the wife's testimony related to why she didn't give it, we have something here that we don't always have, and that is an excellent, well-written final judgment by Judge Jack. She goes through in great detail identifying what was important to her in reaching this issue. There's nothing easy about ruling on clear and convincing evidence in this type of situation, in that this particular issue is not one that's tried often and is a challenging one, both for the lawyers and the court. But here she did an excellent job in describing why she did what she did. And one of the best things she described that is strictly left to the trial judge is a discussion of how critical in corroboration of the wife's testimony the husband's testimony was. And it goes into great detail with regard to credibility, the lack of credibility, and it ties directly into the definition of clear and convincing evidence. Clear and convincing evidence is precise evidence, well remembered, that leaves very little doubt in the mind of the trier of the fact. You can't do better than that with what her findings were and what she considered. I think that there is nothing more compelling when a witness testifies on the critical issue in the case, the critical issue, in this case, $6 million issue. I don't remember. I can't recall. In one word, I didn't say so and so in the meeting, and the next words, I don't even remember going to a meeting. The testimony. Yes, ma'am.
May I shift your focus to
Certainly.
the testimony question?
Certainly.
Your opponent argues that the trial court improperly relied exclusively on the 2019 income, which was apparently the company's best year, despite at least the experts' testimony that 20 and 21 were pretty much a bust, and the go forward capacity of this company seems to be a little speculative. I'm troubled by the fact that the trial court sort of stopped there on need, and Judge Rothstein, you inquired of your opponent what business records there might have been that the trial judge could have relied on. Could you expand on that a little bit?
Sure, I'd be happy to. The issue with regard to alimony, I have to give a little bit of a preface, which is that, alimony is not an entitlement in any way. Alimony is something that you have to prove a need for. The statute starts with the proposition 6108 that the trial court may award alimony if you prove a need. And I would respectfully submit here that no need was proven, and that the testimony and evidence that was offered on the issue of alimony and entitlement was virtually non-existent. It was vague testimony, not only from the husband, but from the accountant, the poor accountant being limited so dramatically in his testimony because he didn't even get the records that he needed, and some of the records he couldn't even open. And that was 2 or 3 days before his deposition. This is all established in the record. But getting
the
directly,
the records that he couldn't open, you're referring to are the QuickBooks
yes,
materials.
yeah, he and QuickBooks, of course, they're often the most critical records of all that his own accountant couldn't even open. But what was in evidence, there was no testimony at all of substance related to the details of his income other than Mr. Berg and our forensic CPA. And I direct the court's attention to pages 699 and 700 of the transcript, where in that case, Mr. Berg located in the trial documents of the husband a document that specifically established that the husband's deposits into his account when he claimed no income were $65,551 during the exact period of time in question, almost exactly consistent with the testimony of Mr. Berg concerning his income. In addition, Mr. Berg went through and discussed in great detail, or substantial detail, a spending analysis that during a period of time when he claimed no income at all, zero, that not only did he save money, but his spending was exactly consistent with Mr. Berg's testimony, and he used the words dovetailed, that he spent exactly what Mr. Berg testified the competent substantial evidence indicated that he earned. And in addition to all of that, remember, the husband here is seeking alimony related to his need. He offered no testimony at all concerning a standard of living. Didn't do a standard of living analysis. Not that it has to be done, but he didn't do it. During the entire period of time that he claimed he needed alimony, as I've said before, not only did he save and incur no debt at all, but he was supporting his daughter and his grandson. Admirable, but completely inconsistent with a need for alimony. He had this is once again somebody who claimed zero income. He had no intention of looking for another job. He had no intention of changing a profession, wasn't interested in an hourly job, wasn't interested in anything in the way of another job, unless in his own words, it was too good to be true. So the bottom line here is on the alimony issue, and we cite the Ugarte case, which is so often cited and is so dead on it, which is that a small business owner, often his testimony, and this is right out of the case, does not reflect his real income, nor do his records, that you have to look at what the facts are to determine income. Here, the facts are completely inconsistent with any entitlement to alimony whatsoever. I believe that I have covered all of the issues, the judge's findings. These are extremely fact-dependent issues. An excellent final judgment, each and every finding completely supported by competent substantial evidence. And if you look in the wording of the Supreme Court's case in Hooker, which is a case that very much supports our position, this is exactly the type of situation where the trial judge was in the best position to make the ruling that she did. She did so admirably, and it should be affirmed.
Okay, thank you, Mr. Meros. Mr. Weber?
Thank you. I'm going to touch on the alimony issue. The husband testified that 2019, his company grossed $500,000, primarily printing for a single client, PAR, and that the work with PAR went down 66% during the COVID year, and his total gross revenues for the company went to $121,000. Now, those are gross revenue figures of the company. And then the testimony was that there was approximately $28,000 in profit for the year during that year, and that 2021 was worse. And so here is a company that does print advertising, and in the middle of COVID, when everything goes digital, like we're doing here today, having digital arguments and people dealing with a totally different world, that his print advertising business is essentially dried up and been severely restricted due to budget cutbacks of the clients, due to differing trends in the way people consume information. And that was the situation he felt himself in. And he testified that he was trying to still make a go of this company, and at minimum, some form of alimony under those circumstances would be appropriate if the court were going to award 90% of what was in the joint brokerage account to the wife and leave him at a lifestyle that was only a fraction of the lifestyle these parties enjoyed during the marriage. They were living off of $300,000 plus in income every single year into that cash sweep account from their joint brokerage account. And they were driving Porsches, they were vacationing, they were doing a lot of different things. And here, the husband would be substantially shortchanged without an award of alimony. With reference to the BMY stock, again, any findings regarding this 2011 meeting, they want to ignore the subsequent 2012 and 2013 decisions. So the wife is a co-trustee with Mr. Snyder, with her uncle of this trust, and again, on 4 occasions, chooses to put this money into a joint brokerage account while they have a very long-term intact marriage. There's no indication there was any discussion before any of those meetings about this being kept separate. Not a single peep anywhere in the record about that. Instead, the entire case relied upon this initial meeting when the grandfather made a gift of the original 55,000 shares, and somehow that's been conflated to apply to all of the decisions the wife subsequently makes about this stock. There's no testimony other than the wife saying, I intended to keep this separate, when you're dealing with all of those transactions that undoubtedly occur. And she had plenty of time after the initial deposit to change her mind or to do something different, or say, you know, I know we put that original 55 in there, Corey, but now these, I want to treat these as separate. I want to do something different with these. I want to hold these as a legacy for my children or for my grandfather or anything else in the world she could have done. And she had to make these transfers because she was the trustee of the trust. And she chose to put them into a joint brokerage account with her husband during the long-term marriage. And I would submit to the court that the testimony was undisputed of total control. In fact, the court described it as extreme control over the account by the husband. Undoubted transfers in there with no contemporaneous indication indicating it was not a gift, certainly as it relates to the last 4 transfers, and not a single bit of corroboration except for the wife saying, well, this was a legacy, this is important to my grandfather, I wanted to hold these shares because it was what my grandfather left me. People make non-business decisions for deciding not to sell stock. Not to mention, it really is undisputed in this record that there would have been built-in tax consequences on the sale of the BMY stock. In fact, as of 2014, the stock was trading at $60 a share. The stepped-up basis was 34. And so the testimony the trial court looks at on the stock consequences is, well, gee, that explains why you didn't sell it the day after it was deposited into the account. It doesn't offer any explanation why it wasn't sold at any subsequent.
Mr. Weber, you have to wrap it up.
Thank you very much, Judge LaRose and panel. This case involves a long-term marriage, and the testimony and evidence offered by the wife to try to rebut this presumption by clear and convincing evidence is simply legally insufficient under Clawton, Erdman, Jurassic, the cases we cited in our brief. They rely on the Archer case and the Lakin case in our support. They rely on the Archer case, which is based on an outdated version of the statute. They can't meet the statutory definition of a non-marital asset. Thank you.
Thank you, Mr. Weber. Thank you both. Very well argued.
Thank you, Your Honor.
And our next case this